Corruption in Ukraine. What needs to be understood and what needs to be done? It is usually at least helpful and more frequently necessary to understand the nature of a problem before solutions to it can be developed and implemented. To understand the issue of corruption in Ukraine, I will organize my remarks first by posing and then by offering answers to 4 questions. Namely, first question, why has there been and why does there continue to be such a high level of corruption in Ukraine? Second, what can be done about it? Third, how can that which needs to be done be accomplished? And fourth, who can accomplish that which needs to be done? Preliminarily, though, we should all first be clear about what we mean by corruption. And based on my continuing interaction and discussions and participations in conferences such as the one that took place in Kyiv several days ago, there appears to be some conceptual confusion as to what corruption is. That is to say, everybody in Ukraine understands that bribery is an example of corruption. But for some reason, at this conference that I attended several days ago, there were people who thought that there was good corruption and bad corruption. And I had to spend some time explaining that, no, that doesn't make any sense. There's no good corruption. Another person thought that everything bad that a government did was corruption, such as monopolization of power. And I said, no, that's not corruption. Corruption means something fairly specific, which I'll define in a minute. I mean, monopoly may be bad, but that's a separate problem that requires different kinds of solutions. So, corruption refers to the misuse or abuse of public assets by public servants, either by themselves or in combination with other public servants or private individuals, whether for personal, familial, partnership, or partisan gain. The public assets most often are money, but may also be real estate, personal property, or simply information. Examples include bribery, theft of state assets, conflict of interest, and various other schemes. When I spoke about conflict of interest before various Ukrainian audiences back during the 2.5 years that I served as a resident legal advisor at the embassy, U.S. Embassy in Ukraine between 2007 and 2009, when I worked on the anti-corruption project that was introduced earlier, no one seemed to understand what I was talking about when I talked about conflict of interest. It's my impression that things have changed somewhat since then, but just to be sure that we all understand each other, let me explain so that we may avoid any confusion. Conflict of interest rules prohibit a public servant from making any decisions or taking any actions that favor his or her private or familial or partnership interests over the public's interest in honest services. Thus, to cite some obvious examples, if I am a public servant, I cannot hire my son for a public position. I cannot buy tanks from my wife's firm. I cannot rent computers from an IT company owned by my cum, etc. To give you some examples of how these kinds of things work in real life, in the United States, judges disqualify or recuse themselves from taking any action in any cases in which the given judge may have a financial or personal interest. Thus, even judges on the United States Supreme Court, which is the 9-person court of last resort for all constitutional and non-constitutional cases, justices disqualify themselves if they have a conflict of interest or if they think that there will be an appearance of a conflict of interest. So to give you a concrete example, a Supreme Court justice who, prior to becoming a justice, served with the Office of Solicitor General, which is the Office of Department of Justice that argues cases in front of the Supreme Court on behalf of the government, disqualified herself, recused herself from all cases argued before the Supreme Court by the Solicitor General that were still open while she was in the Solicitor General's office. On a more personal level, when I served as a federal prosecutor, each time that I would officially open a case, I was required to fill out a form and file that form, which is a conflict of interest form, and on which I had to certify that, to my knowledge, neither I nor anyone in my immediate family had any financial interest or any financial connection with the case that I was about to open. Now, I spent most of my time in the prosecutor's office investigating and prosecuting complex financial fraud cases. So there was always a list of either individuals or entities, whether they were companies or banks, who had been defrauded by the potential criminals that we were looking at. So it was important to make sure that neither I nor my wife had any relationship to any of the victims that had been victimized by the perpetrators of the fraud. Moving on to question number 1. Why is there such a high level of corruption in Ukraine? There is corruption in every country, but in some countries, the levels of corruption are low. In others, they are high or very high. Greed for money, greed for feelings of power, a lack of civic responsibility are found in certain individuals in every society. But the per capita incidence of such individuals should be expected to be approximately similar in each country. So why are there such wide variances in corruption among different countries? I would suggest to you that where there is a similar or identical history, corruption levels can best be understood regionally. In the case of Ukraine, Russia, and other post-Soviet countries, high levels of corruption cannot be understood without understanding 3 central features of Soviet society, whose legacies continue to haunt Ukraine to the present day. These features are, first, moral degradation in the public sphere. Second, virtuality, that is, the practice of systematically pretending that things are different than they in fact are, the so-called Potemkin village phenomenon. And third, the fundamental deformation of the Soviet legal system, so that the rule of law was minimally present or altogether absent. When I came to Ukraine for the first time in 1989, when it was still part of the Soviet Union, I heard a number of anecdotes, 2 of which I have never forgotten, and both of which relate to the related pathologies of moral degradation and virtuality. The first anecdote that was told to me was, quote, "They pretend that they pay us and we pretend that we work," end quote. And the second was the repeatedly offered insight by my wife's relatives and other people that I met that in order to understand anything in the Soviet Union, one had to understand that people, quote, "say one thing, think a second, and do a third," end quote. But it was Nikolai Ryzhkov, the Prime Minister of the Soviet Union under Gorbachev, and one of the architects of perestroika, who revealed the pervasiveness of these 2 pathologies when he said the following in 1985. The moral state of Soviet society was, quote, its most terrifying feature. Quote, "We stole from ourselves, took and gave bribes, lied in the reports, in newspapers, from high podiums, wallowed in our lies, hung medals on one another, and all of this from top to bottom and from bottom to top, end quote. The third factor was the catastrophic decision by Lenin, Trotsky, and their Bolshevik co-conspirators to completely disband and dismantle the existing Russian imperial legal system and substitute for it people's courts, the troikas, the show trials, and the kangaroo courts, all totally subservient to the Communist Party, all divorced from considerations of justice as understood in the West, and instead all primarily in existence to help the Communist Party and government control its population. This was a system that the Harvard historian Richard Pipes aptly characterized as a system of legalized lawlessness. I think of it as a system of imitation legality. And its legacy in post-Soviet Russia was also aptly characterized by then President Dmitry Medvedev during a moment of intellectual candor as a system of legal nihilism. As one of the post-Soviet states, Ukraine has thus been cursed to labor under the weight of the three social and intellectual pathologies whose poisons penetrated its society: moral degradation in the public sphere, virtuality, and the foundational deformation of the legal system. The pervasiveness of corruption in Ukraine and its equal pervasiveness in Russia and other post-Soviet states cannot be understood without understanding and taking into account the three historical legacies identified here today. And, of course, given that existence, there is an ongoing need to push back against those legacies and those tendencies. Question number 2. What can realistically be done about the high level of corruption in Ukraine? One often hears, both in Ukraine and in the West, that corruption in Ukraine needs to be eliminated or defeated or combated. Now, military terms may convey a sense of urgency, but in this context they tend to confuse or mislead more than they illuminate. All countries and societies have corruption, so the distinction is not between those that have it and those that do not. The distinction is rather between those countries whose level of corruption is systemic and those whose level of corruption is merely episodic. All countries can be said to be found somewhere on the imaginary corruption scale, those in which corruption is widespread, in which society's attitude is that corruption is normal or inevitable, in which there is no genuine effort to prevent corruption, and in which there are no law enforcement institutions that have the will and the capacity to investigate and punish corruption, are the countries on the far end of the scale, on the side of systemic corruption. Those countries in which corruption is infrequent, not frequent, whose societies hold corruption to be abnormal, where there exist rules, procedures, and mechanisms to help prevent corruption, and in which there exist effective law enforcement institutions willing and capable of investigating and punishing corruption, are the countries that are on the other side of the scale, on the episodic corruption end of the scale. And of course, there are many countries that are somewhere in between on that scale that I've been talking about. What needs to be done and can be done is to genuinely begin moving Ukraine from the systemic corruption side of the scale towards the episodic corruption side of the scale. That is what most countries in the West did some time ago, and that is what Georgia, the country Georgia, not the state of the United States, did more recently. And that is what needs to be done and should be done in Ukraine. Now, I believe it's fair to say that some initial beginnings have already been made, but they seem to be a bit slow and tentative. Just to give you a sense of how corruption is dealt with in a country with episodic corruption, such as is the case in the United States, several weeks ago, the Department of Justice, for whom I used to work before I retired a year ago as a federal prosecutor, filed an indictment, which is a charging document, charging bribery and other crimes against one of the most powerful senators in the United States. It is also interesting to note that this senator, a Democrat, is from the same political party as is the President of the United States, who, of course, appointed the Attorney General, who in our world is the Chief Prosecutor, who is also a Democrat, who is the head of the Department of Justice. But none of that made any difference to anyone, nor was there any public discussion or debate about the fact that the Justice Department in a Democratic administration indicted a powerful Democratic senator. Instead, all of the discussion and debate in the press was about whether there really was or was not enough evidence in order for the prosecutors to be able to persuade a jury of 12 individuals to convict the senator. And obviously, no one is going to know the answer to that question until the case is presented to the jury at some point in the future. Now, corruption charges against United States senators are quite rare. This is only the 12th time in the country's history that a senator has been charged criminally. But corruption charges against state governors are much more frequent. For example, since 1961, the state of Illinois has had 7 different governors, and in the United States, governors are elected, not appointed. Some of them were Republicans and some of them were Democrats. Of those 7, 4 of the governors were convicted of corruption and sent to jail for long terms. Although this statistic is striking, it is not typical as regards most governors in most other states. I mean, Illinois, I don't know what's in the drinking water in Illinois, but whatever it is, they ought to change it. Corruption on the part of mayors of certain cities and corruption on the part of other local officials in some states is a never-ending problem. But such activity is routinely investigated by the FBI and other federal agencies, and where there is evidence of corrupt activity, it is prosecuted by the Justice Department or by state prosecutors. On the other hand, corruption among federal judges, federal prosecutors, or among agents of the FBI and other federal investigatory agencies is very, very rare, like once every 10 years. My point is that there are no perfect people nor any perfect societies anywhere, but in some countries, corruption is controlled by both preventive and punitive strategies, and in other countries where corruption has become systemic, it is not. Question number 3. How can the level of corruption in Ukraine be reduced so that it becomes controllable, in other words, so that it becomes merely episodic? There are 3 fronts or 3 domains in which action needs to be taken simultaneously in order to genuinely reduce corruption. I emphasize the word genuinely because of the virtuality disease with which post-Soviet countries such as Ukraine were deeply infected. As a result, although there have been innumerable campaigns against corruption in Ukraine since its independence, most or all of them were in fact make-believe campaigns. The 3 fronts or domains regarding which activity must be mobilized are, in no particular order, law enforcement, societal attitudes, and economic incentives and disincentives. Once again, action must be taken with respect to all 3, because otherwise any corruption reduction campaign will fail. Thus, a majority in the Ukrainian society must come to understand that widespread corruption is not normal, not inevitable and not acceptable in a healthy society, that corruption is a social cancer that undermines and destroys real democracy, a real market economy, and therefore a chance at national prosperity. And, perhaps most importantly, it destroys any chance that a country has to improve its level of rule of law. And thus, corruption destroys any chance for justice. It is necessary for a society to change its attitudes towards corruption because the avoidance of corruption must, to a significant degree, be voluntary. There is no law enforcement system in the world that can investigate and punish a quarter or a third of a nation's entire population. Happily, as the result of, and as reflected by the Maidan, the change in attitudes towards corruption has undergone a major shift in Ukraine in a positive direction. But more needs to be done. Civil society and its NGOs must continue to exert pressure for true reforms. Journalists need to continue to monitor the distance between words and deeds. And religious communities, to the extent that they are not themselves infected with corruption, need to be mobilized to play a part. In short, everyone in Ukraine needs to come to understand the moral destruction caused by corruption and needs to appreciate the correlation between levels of corruption and national economic well-being in terms of per capita GDP. Economic incentives and disincentives are independently important. If a public servant earns a salary on which she cannot support a normal lifestyle, then it perhaps should not be surprising that she may seek bribes. Singapore is one of the few countries that managed dramatically to reduce its level of corruption. Singapore paid its top civil servants $1 million a year. Now, even the President of the United States does not earn half that much. And I understand that Ukraine is experiencing economic difficulties for understandable reasons. But the issue of economic incentives and disincentives cannot be ignored. Business in Ukraine and the people living in Ukraine must come to understand that it is immeasurably more preferable economically and morally to raise taxes a bit so that public servants receive a decent salary than it is to have to spend the same amount of money to pay bribes to those very same public servants. Just as there are public servants and private individuals whose salaries are modest, but who will not engage in corruption because their integrity will not allow it, there will always be public servants and private individuals who are already wealthy who, nevertheless, will engage in corruption because they are endlessly greedy. That is why an effective system of law enforcement, whether in Ukraine or Singapore or the United States, is an absolute necessity. By an effective system of law enforcement, I mean the following. Although it may take a longer time to reform the entire judiciary and the entire procuracy, I mean a system in which at least the unit of the judiciary that would be responsible for hearing corruption cases is staffed by judges who have demonstrated high levels of integrity and competence. A system in which at least the unit of prosecutors responsible for taking corruption cases to court would be staffed by prosecutors who have demonstrated high levels of integrity and competence, and a system in which the unit of investigators and analysts that would be responsible for discovering and gathering evidence of corruption is staffed by detectives and analysts who have demonstrated high levels of integrity and competence. Last, but certainly not least, an effective system of law enforcement would have to operate in a legal system in which the level of rule of law, and thus of justice, would be high enough to engender public confidence in the fairness of the corruption investigation and prosecutions that were conducted. Juries are one of the best mechanisms ever invented to help ensure such confidence. Question number 4. Who can do that which needs to be done in order to reduce corruption in Ukraine? The answer to this question is everyone in Ukraine must contribute. Every public servant, from the president to judges to prosecutors on down to the lowest clerk at the local level. Every resident of Ukraine and every business operating here must participate in reducing corruption, because otherwise things will not change. Corruption is something that was one of, or perhaps the principal motivating factor behind the Euromaidan. But it must continue to be an issue of concern, and everyone must not only refuse to participate in low levels of corruption, but must demand and keep demanding of their political leaders that grand corruption at the top and bribes must be controlled, and that effective law enforcement finally be created and its work facilitated. Several months ago, a prominent businessman in Ukraine was interviewed in the press. He stated that he expected that Ukraine's new post-Maidan government would immediately enforce a zero-tolerance policy towards corruption. The fact that it had not was profoundly disappointing, and that it seemed that nothing had changed in Ukraine. Such reports and analyses are both inaccurate and harmful. There is no magic wand that a president or a prime minister or anyone else can wave to reverse and correct many decades of public corruption. On the one hand, it is of course understandable why people in Ukraine feel such a high level of pent-up frustration. But on the other hand, it is important to avoid cynicism and a kind of intellectual laziness that may be involved when, without taking the trouble to get into the weeds, as we say, or to get into the details, some analysts or journalists simply throw up their hands and repeat that nothing has been changed. Even if there has only been a 10% or 20% less corruption thus far, it is important that this 10% or 20% be noticed and acknowledged. Because instead of developing momentum towards more positive change, discouragement and inertia will prevail, and even those 10% or 20% reductions in corruption can be reversed and lost. A few concluding words about an effective system of law enforcement. Given the state of the post-Soviet legal system in Ukraine, establishing units of judges, prosecutors, and investigators with high levels of integrity and competence may not be easy, but it can be done because of an important confluence of circumstances today. There is now, on the one hand, a will and desire in Ukraine to make this happen. And, on the other hand, there is a good amount of international assistance ready to help with both resources and advice. What Ukraine needs to do is to find or provide appropriate leadership for each of the units that I have discussed. This leadership needs, first, to understand the post-Soviet legacies and tendencies of the Ukrainian legal system so as to provide a counterweight to them. Second, it needs to possess some experience and understanding of international systems and standards for reducing corruption. And third, it needs to understand how the international community can help and how to make best use of such assistance. Such units and their leadership must, of course, be independent so that they are not themselves compromised or politically undermined. Taken in its totality, there is obviously much to be done, and it will not be easy to accomplish all of that which needs to be done. But it must be done in order to reduce Ukraine's systemic corruption and to create a new Ukraine so that its former Soviet identity becomes merely a matter of historical curiosity. Thank you for your attention.